Welcome to the Search and Seizure Show. My name is Anthony Bandiero. With me is the great Ann Kehler, Esquire, master's degree, and our longest tenured search and seizure instructor. Now part-time because she decided to go back to prosecuting people, which is, I don't blame her. All right. So we have a really actually pretty intense show in a sense. We have a lot of questions. I want to kind of dive into some of these. But one thing I also, Ann, there's going to be some questions that we can probably just answer fairly quickly. And I say with those, let's answer them and then move on because there's probably some other ones that are more worthy of deep diving.
Oh, yeah. We've got some great questions today. So
we do have some great questions. Now, the other thing is, Colby says, how do you ask questions? This is how we're going to work it, right? The people who are willing to just turn on their mic, get their questions answered. If there's time at the end of the show to answer text-based questions, we will, but we're always going to give the the priority to people who are willing to get onto the show. It makes it more fun, interactive. You do not have to share your agency, first name only, and there's no video. So if you want to ask a question, all you got to do is put mic or, whatever, and we'll ask permission to turn your mic. You'll agree, and then we'll go from there. All right. So until I see that, we're going to dive into our first question. Let me see. I know there's one officer who, and say hello to everybody too, please. I don't have the regular intro that I normally have for webinars. So please, say hello, where you're from and so forth to our fellow friends. Let's see, Sean. I'm looking for Sean, but he is, I see a Sean, but that's not the right Sean. So I'll keep an eye out because we have a Sean that wants to ask a question. All right. And then Ann, do me a favor too. If you see somebody who wants to speak, do you have your chat box up?
I do indeed. I got Sergeant Densmore from Edgefield County. Hey.
Cool. All right. Good. All right.
Nebraska's in the house.
Yeah, Nebraska, California, South Dakota, and so forth. So if you see somebody that wants to ask a question, just make sure you let me know so I don't miss it. Okay.
Awesome. Aaron's on there too.
Oh, so. Aaron. Okay, good. I'll help watch for questions. Excellent. Okay, guys, let's dive right into this. So we do have a question by name gang, Sean from Iowa. So until he comes on, I know he's going to come on and ask, but until then, let's go to this next question. So we have a question from Leonard. He's from Wyoming. I'm going to keep the agencies out of it because some, people may not want their agency, but Leonard from Wyoming. All right. So here it is. When would, if necessary, the family begin to have reasonable expectation of privacy over a deceased family member's cell phone? And we've been asked this question several times. All right. It typically occurs when people overdose and police want to search that phone for evidence of the overdose, right?
Right.
All right. So the background here is, we had a discussion regarding individual who committed suicide in our jurisdiction. So the person was, going through a fentanyl withdrawal, and unfortunately, he ended up committing suicide. So the question is, all right, let's say the family has the phone, right? And the police want to look in that phone. Can the family give consent? That's something we commonly hear. Or more likely, the police have the phone in their custody. Can the police look into the phone? Let's say it doesn't have a password, but let's say it does have a password and we use a program like Cellbrite or something like that to get into the phone. They find evidence linking a drug dealer with the cell. And can police do that? Yes or no, and why?
I say yes, because reasonable expectation of privacy goes to the owner. And unless we can establish that someone else has an expectation of privacy to that phone as an owner or as a third-party user of that phone, then reasonable expectation of privacy goes with the owner. And if the owner is deceased, well, at that point, there's no more expectation of privacy. And I think at least two courts would agree with me. There's a case out of Massachusetts and another case actually out of Washington. They didn't have that exact question of they were deceased, but it did talk about whether or not I can look at chats on someone else's phone and whether or not the person who sent those text messages or made those calls to that owner if they have an expectation of privacy as well. And in both those cases, the court said no, the expectation goes to the owner.
Yep. Now, what about, I agree. I can't add anything else to that. I think you answered it perfectly, in my view, I think we both agree on this one. What about the family giving consent? That may make cops feel a little better, but is that an option?
Again, you'd have to establish that the family actually had third-party access, joint ownership, joint access, or control like the owner in order to gain that consent. So once I am deceased, all of my assets are going to go to someone who has power of attorney or someone who has, an heir or something like that. I mean, it can get into kind of this really gritty, wills and trust stuff. But
That's right.
at that point, we were still talking about who has an expectation of privacy. And just because I might take that phone at some point after the owner dies, it doesn't still necessarily go to my expectation of privacy to that phone. So I would always ask for consent.
Sure.
Just because, hey, the family now has custody of the phone and I need to seize that in order to search it. So I'd still ask for consent, just, and they want to know why their loved one passed away as well. So if we ask for consent, we ask for it in a really just kid's glove, very compassionate way. Yeah. Okay. I don't think we necessarily have to, but it's never a bad idea.
It's never a bad idea. And I think the one thing I would add is that when it comes to the no standing issue, right? The deceased is not going to complain about looking through their phone, obviously. I think in my pea brain, I think that the only time it's going to bite cops not getting a warrant is if somehow a person with an expectation of privacy, had messages on that phone, and it could be like, let's say the wife is the one who purchased the fentanyl for the husband. And now the police want to charge her with a crime. And if she has an expectation of privacy, obviously she can complain about the warrantless search. So I guess we're going back to your, maybe she would consent, to search. And that's always a safe, just those, because sometimes spouses do have common authority over each other's phone. Would you agree with that?
Right. I think that I know that the courts have looked at that common authority for spouses in terms of like the wife's purse or the spouse's purse,
right?
And have held that some things are so private that expectation of privacy and spousal, joint ownership doesn't necessarily extend to that really private thing like a purse. So I would still go to the wife and ask her, do you use the phone? Do you access the phone? To what extent do you use the phone? Really good question. How can you prove it? You have to ask. And again, it's what you would reasonably expect at the time of the search that the courts are going to be looking at, not what we learned after the fact.
Yep. So, and then James also says, even if the phone is paid by a third party, let's say, and solely used by the deceased, such as a juvenile case, well, that gets a little complicated, right? I think the answer there would be, if it is a juvenile and the parents have that parent-child relationship, they do have the authority over their child's items. I think would you agree though, it gets a little dicey when the child has his own iTunes account and is adding apps to the phone. The parent may not necessarily have, strictly speaking, common authority over those apps, right?
I would agree with that guardianship relationship, once we allow our children to have a greater expectation of privacy, I think sometimes that guardian relationship can be skewed a little bit. So I'd be a little bit more cautious with that. But especially where we know that cell phones do have a little higher expectation of privacy than just any other container. But knowing that a parent does have the guardianship relationship over a child's room and the expectation of privacy that is generally greater, I would think that guardianship relationship would also extend to phones to some extent.
Good. Now, also, while we're talking here, if somebody wants to ask their question, and it's like a separate question, please just say mic, and we'll, get your consent to turn your mic on. No video, just mic, and you can ask your question live, and we'll answer your question. That's really what we're going to transform this into. Is all right. Let's do it. So Colby wants to ask a canine question, and you have a canine expert here, and definitely knows what she's done. So let me just pull up panelists, participants real quick. So it's Colby. All right, 1 second. Where is my, hold on 1 second. All right, there we go. So Sorry, it just takes me a couple seconds to find Colby over here. I'm asking permission to talk. All right, you can keep your camera off, I think. All right, Colby, I think you can hear us and we can hear you.
I can hear you. Yeah, and don't worry, I'm going to keep my camera off. Nobody wants to see this face. So I got a quick question regarding canine, and I think that I understood it based on your short webinar, but I just want to follow up and make sure that I'm solid on it. Okay.
Yep.
If during a traffic stop, an officer may not have quite reached probable cause that there's drug activity going on with this vehicle, but it's more than just a hunch. It's somewhere in the reasonable suspicion category. Is the officer allowed to extend the traffic stop for a canine to get there to perform a sniff? And the second part of that question is, I guess, how long can they extend it? I'm sure there's no straight hard rule on that, like 45 minutes or 46 minutes, whatever. But let's say that the officer is off shift that night. An agency only has one canine, but this is a big traffic stop. They've been looking for this guy and they need a canine out there. Would that extend to that situation as well, as long as the canine officer who got called in didn't stop and get a coffee or something?
Yeah, the whole Starbucks thing. Right. Ann, what's the answer?
If you have reasonable suspicion that drug-related activity is afoot, then you can extend that stop to start investigating that. But you have to have RAS. You have to have reasonable articulable suspicion that it's drug activity. Now you can call your drug dog and wait a reasonable period of time for that dog to arrive. And again, you're exactly right. There's no cut and dry. It's a reasonable amount of time. Where is your dog? Yep. How big is your area? I've seen courts go up to an hour.
Yep.
The stronger your RAS, the more reasonable that amount of time is going to take. And the idea here is it is less restrictive, right? You're not digging through their car or digging through their life. You're just waiting for a dog to come and do a sniff of the vehicle in order to allay your suspicion. So yeah.
And that's the answer in every state, by the way. Just so you know, every state will allow you to further detain a person for with reasonable suspicion for narcotics. Some states require reasonable suspicion to even call a canine, to even run a dog. So there's no free air sniffs in some states like Pennsylvania and New Mexico and so forth. New Mexico, right, Ann? Am I right? Yeah, I'm right. Yep. Yeah. But the only state that has a restriction, just for our trivia, is Nevada. Nevada is a strict 60-minute rule on all reasonable suspicion. And that's by statute, not by case law. All right. Thank you, Colby. Did I answer your question?
I appreciate it.
Awesome. All right, cool. All right, excellent. So that's how it works, guys. If you want your question answered by us, all you have to do is say, Mike, ask whatever you want that's search and seizure related. If it's statutory based, we may not know your answer, but we are experts at search and seizure in case law. All right, let's do another question. So Kenneth has a question. All right. Hold on one second. Let me see. Kenneth. Sorry, I have to go through all these names to find Kenneth. All right. All right, Kenneth, you're on the love line with Ann and Anthony.
So I have a question. I'm in California. It's in regards to marijuana in the vehicle. And I know as far as like the vehicle exceptions, whether or not if you can actually search if they say they have marijuana in the vehicle or if you smell burned or unburned marijuana as well.
Yep. So I can take this, Ann, I'll take the first shot at this. So here's how it works in California. So the smell of raw marijuana in and of itself is not probable cause to search a vehicle. They are allowed to have an ounce of marijuana if they're 21 or over, right? Now, if you have other indicators that they are involved in criminal activity, then of course that changes the analysis. But what some cops call this is compliance checks. Some cops want to check a vehicle to make sure that the person is complying with applicable marijuana laws. That's not the case. No state allows that. Initially, when marijuana became recreational use around the country, some courts were willing to give cops a little latitude with that, but they have righted themselves and got in line with the Fourth Amendment, which requires probable cause. The smell of burnt marijuana in and of itself may not be enough. California and Illinois have 2 cases on issue. However, The truth is that both of those cases, in my opinion, were badly articulated by the officer and the prosecution, because they really couldn't pinpoint that the marijuana was smoked by the driver in any time recently or while they were driving. So if you have probable cause that the person was smoking while driving, and during that travel, during that, instant case, I think you can search for evidence of that because it's illegal to smoke and drive. Ann, anything to add on that?
Yeah, I would agree with that. Absolutely. That just about every single state that has recreational marijuana has laws about when it can be used. It has to be purchased at the place and then taken to its location of use to be used. It can't be used in public at all. I think Connecticut's the only state that doesn't have any restrictions on when it can be used.
Oh, really?
So,
okay. Right.
Yeah. So
You can.
if you can articulate that it was used in public, which is inconsistent with state law, then that can give you, I believe, probable cause. So if
Okay.
you can articulate use in public, I think you would have a better case there.
Awesome. All right, Ken, did I answer your question?
Yeah. So what I gather is like, so if they're using it in public, that pretty much gives you the PC to search for, the marijuana inside the vehicle, so to speak.
So
At least
you're,
evidence of use.
go ahead, Ann.
Yeah, I said at least evidence of use in public.
Correct. Yeah, you're looking for, you're going to take pictures of it to prove that they were indeed smoking marijuana, not clove cigarettes and so forth. So the answer is yes, but they had to commit a crime first. All right.
Oh, okay. Thank you.
You're welcome, my friend. All right, let's go to another question. So this one comes up frequently, and it's about Miranda, during domestic violence investigations. Look, I can kind of get into the background, but it's a fairly common question. Officers arrive at scene on a domestic violence or family violence, like they call it in Texas. And this officer, actually, I don't know where he's from. I think it's Utah, but I'm only guessing there because of the email name. But what's the rule there? And they show up to a domestic violence investigation. And at what point do you think they have to start reading Miranda?
So it really does come down to because we clearly have, an investigation, but at this point, it's usually just they are detained until you are able to sort out what's going on. So you definitely have a known officer, but you don't necessarily have custody, which is something you absolutely have to have before you have to Mirandize. So I think the ultimate question comes down to how many people have responded to your DV case. If you have 12 officers who have shown up and you've got a person sitting in their living room surrounded by cops, absolutely, that's going to be a custodial interrogation. But if you just have, I'm talking to one party, you're talking to the other party, and then we swap, it's going to be hard pressed to say that's a custodial interrogation under those limited circumstances. So it comes back down to, absolutely comes down to, is what did we do? How many people, how many guns, how much stress we placed on the participants there prior to asking questions. So premature, we want to avoid at all costs, right? Premature,
arrest like custody, pretty much, right? Almost like arrest like custody. I mean, the way I look at it, Ann, is I say to myself, look, first of all, we have to understand when Miranda, we have to understand why Miranda. Miranda's trying to prevent the inherent coerciveness of arrest like custody. When we arrive on scene and cops are just trying to find out what the heck is going on, there's really, generally speaking, not arrest like custody. There's no looking for confessions. I know you did it. Why'd you hit your wife type stuff? Probably it's not gonna be 12 cops on scene, like you said. So we have to look at the totality of circumstances. Now, when we're looking for confessions or we have a high level of coerciveness, for example, handcuffs. Now, handcuffs in and of themselves, right, don't require Miranda, but they are very coercive, right? Putting somebody in the back of a police car. I mean, yeah, I say you probably need Miranda, but there's always an exception. But the point is we can't, there's no black white answer here. It's a totality of circumstances. But I think that the main thing we can tell our viewers is this: if you are really just trying to figure out what is going on, and that's how you're acting, that's how you're talking, even though the person is not free to leave necessarily, you may not need Miranda. But once you start looking for the confession, the admissions, you probably need Miranda. Is that a fair kind of a general guideline? Ann, what do you think?
Absolutely. And I love the way you put that, when you teach and when you talk about this, inquisitive versus accusatory. If I'm
Right.
just asking, hey, what's going on? Tell me more about that versus you did it, you did it, right? That can have a big effect on that as well.
Good. Now let's roll to another question because we have a lot of them. And again, if somebody wants to say, hey, I want to ask a question live to the great Ann Kehler, just say Mike and we'll answer your question. One related question that we also got in, Ann, was having to do with this. It is a Texas specific thing, but I just want to answer on this podcast. It has to do with an officer said, hey, look, do we have to read the exact language from the Texas statutory code for they have a Miranda type language. And again, this is not relevant to, maybe most people here, but I just think it's kind of interesting. So Texas has this, it's in Code of Criminal Procedure 3812, and I might be off on that, but 38.12. And so what it says is, it says, you have the right to remain silent and not make any statement at all, and that any statement he makes may be used against him at his trial. Just have to have something that's kind of similar to this. Any statements you make can be used as evidence in court. He has the right to a lawyer, and during any questioning is if unable to employ a lawyer, has the right to have one appointed at no cost. And then now here is here's really the question for us. Look what also Texas adds. He has the right to terminate the interview at any time. Okay, so we know that Miranda versus Arizona does not require that last part. They require the first four, right? So the question for us is that little statement right there, is that required in Texas? Do you know the answer to this one, Ann? Because I had to look this one up, but do you, off the top of your head, do you know the answer to this one?
So I don't know the answer to this one off the top of my head, but like I said, so I'll let you take this because it looks like you've looked it up. But so the last thing we want to do is piss off the judges by not following what the law says. But I would just, in my gut, say constitutionally, generally not necessary.
Well, so federally, we know the answer is that if this case goes federally, you're correct, right? We're not going to require that. The feds don't care about, statutory issues. They care about the Constitution, the Fifth Amendment. However, in Texas, 38.22 requires substantial compliance. And in a case called Hernandez versus State, Texas appellate court in 2017, I can just give you I'll just write it down, while you're getting your answer. Another one, I'll put the citation in the notes. So if anybody cares, but in Hernandez, the court says that the warning must substantially comply with 38.22 and basically convey on the face of the statement the exact meaning of the statute, even if it's slightly different language. So our advice to Texas officers is to just read the card that you're given. It's going to have that you may terminate at any time. It is what it is. Constitutionally, not required. Statutorily, is required. And we also know from Texas that they will suppress evidence if you do not comply with the Code of Criminal Procedure. Ann, how the heck did you find that so quick?
It was in your answer that you emailed me earlier today.
So you cheated. All right.
I cheated. I like to cheat. I did look like Chase did have one other question in there really quickly with regard to asking the last two questions that we always suggest you ask. Do you understand? And do you want to talk with me? Those are never, like I said,
that's right.
Express versus implied consent. That last question, do you want to talk to me? I do encourage you to ask that last question because it's express consent. When they say, yeah, I'll talk to you, boom, so much easier to justify that.
But you don't need it though. You don't need Texas. But Texas does recognize implied consent. All right, so let's do some microphones here. Brian, are you ready to go with the domestic violence question? Brian. All right, Brian, you're on deck. I just want to make sure before I ask to turn on the mic. All right, cool. And I don't think you guys have to worry about video. I don't think it's even programmed to even turn on video at all. You don't even have a choice. All right, Brian, you're on deck. What do you got?
So in relation to the domestic violence, let's say the caller is next door neighbor and they say they're fighting out in the yard and I think he pulled a gun on her. So we roll in, hot and heavy, whatever. He's at gunpoint, proned out, cuffed, standing back up, separate them. So custodial like arrest. But let's say we find out very quickly in speaking with her and him that nothing like that happened. They were just arguing.
Yep.
Can you go back from the custodial like arrest and,
And wind it and unwind it.
Conversational tone, maybe
Mhm.
even take him out of handcuffs if you want, if he's, not giving you any indicators of threat or flight, that kind of stuff.
Right. Yeah.
So
Okay.
that's my question.
Yep. Ann, what's the answer?
You can absolutely walk that back. And just like Anthony said earlier, the whole reason we are asked to do Miranda is to address the stress and duress that comes with custody. So if we can walk back that stress that was created when we first arrived, new location, out of handcuffs, and it never hurts to let them know, hey, you're just being detained. We're just trying to figure
Yep.
out what's going on. That conversational tone, reducing the number of officers dealing with them. That might be a great time for a kind of a modified Miranda out of that, we might take from Berkmer, just to say, hey, you know what, this is what's going on right now. Do you want to talk with me about that? So yeah, you can
Yep.
absolutely walk that back.
Now that's called taking the custody out of a detention.
Yeah.
And another pro tip, and to add what Ann said, is I think she probably actually said this or implied at least, is that you just tell the person in no uncertain terms, hey, you are not under arrest. You're just being detained. We're just trying to figure this out. Now that we know that this is not exactly how it happened, what is really going on? So the point is that you can actually have, remember, Miranda is required under two circumstances: a formal arrest, which did not occur here, or arrest like custody. Once arrest like custody has been removed, you go back to regular rules of no Miranda. All right. Did I answer your question, Brian?
Yes, sir. Yes, ma'am. Thank you.
You're welcome.
Awesome, sir. Thank you.
All right. On deck. And now this one, Scott, do you want to answer your question or ask your question? We can't make any promises, though. You might have a statutory question embedded here, but we'll take a stab at it if we can. Okay. Scott. Okay, Scott, you're on deck. Hopefully we can have your answer.
Yeah, so in Texas, we're getting a lot of what we call deferred sentencing, especially on felony offenses. And so what that does is it changes it from a conviction back to just an indictment.
Mm.
And then these guys get put on paper. And so they're on probation, usually for several years. And we're running into instances like where we will find them with firearms and guns on them. Of course, being a constitutional carry state, it's violating their probation, which is a get a warrant later offense, not a put them in handcuffs right now offense. Can we still seize that weapon from them since it's going to be evidence used in a later offense, but not in this crime?
I mean, I think I have my answer. What do you think, Ann? What comes to your prosecutor brain?
I don't know.
Yeah. We're taking a risk on this one because you're not a Texas prosecutor. I think the answer is yes, because you do have evidence. You can seize evidence for it would be a crime, right? If ultimately they would be indicted for possessing a firearm while they are under probation. Or is this a civil thing?
No, it would be an arrestable offense, but it's going to have to be reported to their probation officers, and their probation get revoked later at a later time.
Well, I think that's the answer then. I think, Texas allows you to recover evidence of a crime. So without an arrest, you don't have to have an arrest to recover evidence of a crime.
Okay.
Right. And
I said if they are court ordered not to have weapons or as part of that deferred deferred agreement or whatever, I think that, you can absolutely.
I mean, they agreed to it. They agreed to do this, hey, I'll stay out of trouble. No firearms, no smoking weed, whatever. And if they violate it, then that causes them to have their other original charges back and some new charges. So I think our answer is yes, but of course, with the caveat, check with your local prosecutor, make sure that we get it right too. We're just some lawyers, on the internet, right? So we don't have as much influence and of course, as your local DA, but it is a good question though.
The other, just really quickly, the other thing I would do there is I call the PO. And because now you have reasonable articulable suspicion that there's probation violation, you can extend the stuff based on that. Call the PO and say, hey, this is what I got. How would you like me to proceed? And then act as the agent of the PO.
Cool.
Yep.
Right. Okay.
Hopefully, thanks, Scott.
Of course, Colin. Everything on the interweb is true.
Yeah, exactly. Okay, so the next question comes from Officer Shannon in Colorado. So the title of the question is, can we immediately search, not frisk, a suspect on a felony menacing for a gun? Basically, what happened here is we got a call for a felony menacing, right? So, pointing guns at people and so forth. Called them by a witness who said that they saw a male pull a gun at another male and point it at him. So sounds like illegal conduct. As we, or could also be self-defense, I guess. But as we got on scene, an officer made contact with the witness and pointed out the suspect across the street. We put the suspect in handcuffs and then immediately searched him, first seeing a knife in his front pocket, removing it, and then searching for the gun. Now, the officer is saying, hey, look, this is not a frisk. The way we did, we went right into the person's back pocket and removed the gun without feeling it first. Are we justified? What's your contemplation on this one, Ann?
So it sounds like, so we've got a confident, or not a confident, citizen informant, concerned citizen with a solid basis of knowledge who gives us information that would lead us to have probable cause that a crime has been committed, especially a weapons related offense. If that justifies a search incident arrest, I think we're golden. If we don't quite have probable cause in a search incident arrest, I would start with the frisk. But yeah, I mean, we've got a lot of cool things going on with this question where we do have that known, known caller. Like I said, anonymous caller would be very different, but we have a known caller, concerned citizen, basis of knowing, gives us information, is able to identify that's the guy over there, corroborating that. I think that gives us, probable cause and search incident to arrest. So
I agree. What's that case where the Supreme Court, said that you don't have to, subjectively say, hey, you're under arrest, then search? Is that Rawlings versus King?
I think so. Yeah. It's like, so long as you have probable cause for the arrest, it doesn't matter. It's contemporaneous to the arrest, and contemporaneous can be before or after. You don't have to say you're under arrest, then search.
Yes. So I think push comes to shove. I think that this case, I agree with you. I think it is going to hold up. The courts presume that witnesses are reliable. Now, that doesn't mean you take them, whatever they say goes. It's a two-part test, right? Number one is, why should we even believe this person? Well, if they are an uninvolved, non-criminal, you don't think they're a criminal, an uninvolved person without an axe to grind, then we probably take them at face value. Hey, this person pointed a gun at that person. So we believe that they saw what they saw. The next thing is what they are telling you a criminal act? Well, there's no evidence in this very short description that this was a self-defense, that one person pulled a gun, another person pulled the gun. It just seems like, hey, this person's pointing guns at people, and you have this person just hanging out, not calling the police, not running. So if the person was in fear of their life, they're not acting like a person who just used self-defense. So at the end of the day, I think, and I agree with Ann, I think that this is probable cause thin. It's not the thickest probable cause, but I think it's good enough for government work, as they say. Ryan?
Yep. The other, like I said, the other thing that Shannon kind of suggests here is we reached in and pulled out the gun. We don't have to feel it if we see it. So that can also work under plain sight.
If indeed they did see the gun. Now, the seeing the knife, by the way, if we're still in reasonable suspicion land, seeing the knife is not going to allow us to just reach into pockets, because that's not probable cause either. We would still have to do a pat down. But again, I think we're saved here by probable cause.
So
all right.
The only other thing I would say about this is be very, very careful with the word automatically. Do we automatically get? I see that a lot and I hear that a lot. Remember, nothing in search and seizure land is automatic. You always have to articulate reasonableness under the circumstances.
The only thing automatic is some of these toys back here, huh, Ann? Huh? Forget about
my automatic rifle, man. That's one thing about law enforcement I miss is
I know you got a little.
There were a lot of ARs, but that one was mine.
Yeah, a little take home full auto.
Yeah, it was.
You got a car, a dog, and a full auto. That's America. That's America right there.
That's Idaho. Welcome to Idaho.
All right. So Amanda, exactly. That's how you spell it too. All right.
Sure.
America. So Dustin, who works in Indiana, is saying, hey, look, can police basically disarm a person for having a firearm for officer safety? So the background here is the officer stops a vehicle for a very minor traffic offense, right? Let's say speeding. The subject tells the officer during the initial contact that they have a firearm on them, or let's say it's in the glove box. Now, this is not illegal in Indiana. Indiana is also a constitutional carry state. The stop is complete for officer safety reasons. The officer, let's say just during the traffic stop, the officer takes possession of the gun until the stop is over, right? And then gives it back. Are we good here? Can we seize that gun for officer safety? And I think this is actually a good segue, Ann, because you just got done saying there's no automatics in the Fourth Amendment. What about this one? Is this an automatic to you?
This is not an automatic. Again, and actually when I was first, I just come back from academy, and of course, when we're at post, everybody's going to try to kill us, so we're always on edge.
Yep.
And I started doing this on every single traffic stop. And my FTO was like, "Do you realize you're in Idaho? Do you realize that you're going to be doing this in every single traffic stop for the rest of your life?" It's like, okay. So it really did come down to, is there a reasonable basis for seizing that weapon? And I know there are a couple of states where there's statute that says you can, but just because statute says you can doesn't mean the Constitution is going to bear that out, especially in a constitutional carry state. So I think you've got two great options: consent, which is one of the things the person who asked this question mentioned is, hey, can I ask for consent to keep the firearm, out of the picture until the stop is over?
Mm-hmm.
Or is there a reasonable basis that this person is armed, which I now know because they told me, and dangerous?
Yep. I agree. I think that, I think the problem here is, look, there's a few things here. And I got to tell you, Ann, I was also, when I was a trooper, I was also a person that initially I would disarm people because that's kind of the way I was trained. But when you start thinking about, there's two things. Number one is the more you handle firearms, the more likely the more chances and the percentage you're going to have a negligent discharge and so forth. So, why even introduce a firearm into the, if you don't really need to disarm somebody? Most of these people who tell you, hey, I have a firearm, it's in my bag, it's on my person. I personally have never had any issues. And I'm not saying, you do you, I'll do me. If they keep their hands on the wheel as I reapproach, that's really what I ask for. Keep your hands in plain sight. The other thing is that we do have a case called Davis, and I looked this up, and you might have seen this too, but Davis versus State. It's an Indiana Court of Appeals from 2019. And what they said here is basically an officer, was told by this driver, hey, I have a firearm underneath my seat. And that was not a violation of Indiana law. And the officer says, okay, fine, get out of the car. Let me go grab that gun. While he was under the seat grabbing the firearm, he found the devil's lettuce and charged this guy with cannabis possession. And the court found, hey, when the cop went to court, he was asked essentially, hey, why did you do this? Like, what's your rationale for getting into that guy's car? And he says, gun equals danger. And the court said, no, that's not how it works, right? This person, by law, they are allowed to have a gun underneath their seat if that's the way they want to carry it in Indiana. And I also had a good prosecutor tell me, hey, look, if you have a cop going into court and he's going to argue, or he or she's going to argue gun equals armed and dangerous, then ask that officer, have you ever pulled over an off-duty cop for speeding or whatever? Did you disarm that person? Probably the answer is no. We don't really disarm off-duty cops, right? It's pretty, obnoxious to do that. And then the prosecutor, or not, the defense attorney will say, why didn't you disarm that person? If armed equals dangerous, why are you, right? Just because they work for law enforcement. What about the guy that works for the bank and he works, security and so forth? So I think that's how I look at it too. Anything else to add, Ann?
Nope, that's perfect. I like that answer.
Yeah. But just to let you know though, just this is our viewpoint on this. Ann says some statute. Also, there's case law out there that says that armed is dangerous. Our view, if it went to the Supreme Court, is it's not quite that black and white.
Yeah. So
all right. Go ahead.
Just really quick, Brian asks, is like, couldn't you articulate that stops are inherently dangerous? And I think you just covered that.
Yeah.
Yes, stops are inherently dangerous, but that doesn't mean everyone inside every car is inherently dangerous. So Michigan v. Long is a better case of sight, but the officers actually saw the pipe in the car. And that was dark stretch highway, rural area. Officer was all by himself late at night. There were a lot of other things that added to the inherent dangerousness of that in order to justify that sweep of the car.
Yeah, and it won't take much. I'm telling you guys, if you agree with what we're saying here, yeah, you probably need something more than just a gun and a guy that's being completely cooperative, hands on the wheel, not intoxicated, looking you dead in the eye. But it doesn't take much. It really doesn't. I mean, your officer safety, but I want to say one cop came up to me and says, Anthony, if we only cared about officer safety on traffic stops, if that's all the courts cared about, I would pull everybody out with my Area 15, right? So, I mean, then every traffic stop is as safe as possible. It just doesn't work. We have to have a balance of freedom and the intrusion. Actually, Ann does a lot of, when she teaches her classes, she goes deep into that whole balancing test, and that's part of that. All right. If anybody wants to ask a question, just say Mike, and I'll continue. All right. We have a question from Gregory in California. I know this guy. He actually is a long-time listener. I don't know if he's here today. Hold on. Let's see if Gregory's on here. He's
Long-time listener.
a long-time listener of the of the Love Line. All right. So what's this question? It says, if we have an arrest warrant,
This is a great question.
Yeah, if we have an arrest warrant, do you need a separate Stiegled style warrant? And please explain Stiegled to serve the arrest warrant at the arrestee's place of employment. So basically, we have an arrest warrant for an assault with a deadly weapon. Okay, that's pretty serious. The suspect is known to work at a construction company. The company's property is completely fenced in with a large storage yard and a warehouse garage. Are there restrictions to serving the warrant at a private business, and can the business prevent law enforcement from serving on their property? I appreciate everything you guys do, and I appreciate you. All right. So I try to look up case law on this one. I really couldn't find anything. Maybe you have something else, but what do you think, Ann? What's your answer here?
You know, I would go back to when we can execute an arrest warrant at a home. It has to be their home. You have probable cause that it is their home, reasonable suspicion that they are home in order to serve an arrest warrant at that home. Anywhere else, that business owner, that property owner, that has a separate and independent expectation of privacy, where this business is not open to the public.
That's right.
I think that adds an added dynamic. So I would hesitate to just go into that business to effect that arrest warrant, even if I have reasonable suspicion that he's there, under circumstances in that scenario where it is not open to the public. I think open to the public adds a slightly different level of expectation of privacy, but if there's an office that he is, concealed in, or a shop area that's not open to the public, that I would definitely get in the warrant to search for and arrest that guy.
Yeah, I'm with you on this. And so let me get my 2 cents. So it's not going to be curtilage, right? Somebody's saying curtilage. It's not going to be curtilage because businesses don't have curtilage. Only homes do, right? But businesses have what's called a private expectation of a reasonable expectation of privacy, right? When you have a closed business and it's not open to the public, and police are basically trespassing, probably even criminally trespassing, then it could violate a person's reasonable expectation of privacy. So you have curtilage, and then you have REP, which is maybe not property, that's REP, expectation of privacy, which is not necessarily as highly protected as the curtilage. Still, though, I got to agree with Ann. I think she's exactly right. I mean, you have this area. Well, I'll give you a case. There was a case involving an officer who had probable cause, not an arrest warrant, but had probable cause, who went into a lawyer's office to arrest him, and the court found that was unconstitutional. And why? So the arrest warrant doesn't give you authority to just go and grab this guy wherever he's at. And we also know from Stiegled that you cannot serve an arrest warrant at a third-party home. So Payton is the case where it allows, the Supreme Court says, hey, we can, serve this arrest warrant at his domicile. Well, he's not living at the construction site, right? So that's not his domicile. So we don't get this to go anywhere he has expectation of privacy. A couple of things I'll add. One is that in the Ninth Circuit, which is where this officer is, you need probable cause. Actually, they have a higher standard for you have to have probable cause that the person is currently present during the execution of an arrest warrant. Did you know that, Ann? By the way, kind of a crazy. I have a case on that if you want it. They just make things harder. I'll show you the case later, but I didn't know that either. But they want probable cause, not reasonable suspicion. Most of the country is reasonable suspicion level for being home at the time. And the
Yeah.
other thing is that we have some friends here from Pennsylvania. Another case I read recently is that Peyton, you can execute an arrest warrant at a home, does not apply in Pennsylvania unless the judge specifically analyzed that particular address.
Nice.
All right. Yeah. Well, all right.
Pennsylvania.
Pennsylvania, they are making things hard on our officers. Not only have they lost the car stops or the car searches, without a warrant. Actually, that might be one of the. That's one of the.
Definitely raced ahead of New Mexico.
Yeah, they're competing with New Mexico.
Yeah,
Well,
they
at least it's not, hopefully not going to compete with Washington or Oregon. That's hard to beat. All right, our next question is another one from Colorado. What's this officer's name here? This one is actually. Let me see if Sean is here. I did have. Okay, no, the Sean I'm looking for is still not here. Okay, that's okay. Well, let me do his question then, because I know we're almost out of time, and he actually had a very good question. This is question number 1, and basically it's a kind of a quickie, but it's the utility companies in the Fourth Amendment. He says utility company wants to access a private property to turn a meter off. Let's say because they have not paid their bill, for example. The property owner said no and has a locked gate. So this person is being, difficult, right? The utility company calls the police and they want an escort onto the property. They want their armed guards, to say, hey, protect us while we turn off this guy's gas, right? Are we good? What do you think? Well, there's some more stuff here, like the utility company wants to be proactive and shut off a gas meter for flooding. I think the answer is the same, right? And whether it's, well, actually, no, it's not the same. Let's do the first one where let's say the utility company wants to go on somebody's property to turn off the gas meter because they have not paid. What's your answer there?
That is going to be a civil issue, and you need to get a court order to do that. would be my answer there. There's no harm, there's no danger, there's no they haven't paid their bill. Now it comes down to, have they been given notice? And I think you would need basically a civil standby or court order to go onto that property with that, because we are not going there. There's still a reasonable expectation of privacy. So when we look at our balance, anytime you go onto that property, you're now subjecting that person to your observations. You've got to have a why. And in this case, the why is because he didn't pay his bill. That is not a significant harm. Yeah.
But Ann, I'm the power company, Officer Ann. That's an easement. I can show you the deed. I can show you the paperwork that says we're allowed on there. Doesn't that change? Doesn't that change it for you, Officer Ann?
You're going to be going off that easement onto the property to get to the meter. So there's there's still bases for going in onto that property, even with that easement. You're going to be very limited to what you can go and do. Usually it's maintenance. And again, it's harm and danger. But you're going to the meter, which is going to be in the curtilage of that guy's house and is going to be protected property.
I agree. Look, I'm not sending my guys in and for the gas man. We're not the muscle for the power company. Easements are civil issues. They're contracts. If somebody wants to break their contract and not let the power company on, go to court, get a judge saying, officer, escort these people on. Now, one thing, and I think Brian says they do things differently in California, maybe.
And that's because they have law that covers them in California. So the only case I was able to find on point on this was out of California, where it does talk about property interest in continued electricity that might be cognizable under the Fourth Amendment, extends only as far as state law provides. Disconnection of services comported with state law. There's no violation of protected property interest. And I'll go ahead and put that in here for Brian and for everybody else.
Nice.
But again, that was a matter of dangerousness. There was fires and turning off power in order to protect them.
That's okay. No, don't let me hold it there, because that's
right. I jumped the gun.
No, you didn't jump the gun, but I think that's great. And I didn't know you even found that case. And this is why I have you here. So the next thing is that let's say that because the officer, kind of implies two little scenarios. So one is just we want to turn the gas off. The other one is that there is a flooding in the area. And let's say that the utility company does articulate to the officer that we have an emergency. If we don't shut it off, we could have a gas leak. Does that change your opinion?
It does. It does.
Outside of California too? What about my
Outside
friends in
California? I think that still applies, because again, when we look at our balancing test, why am I going on the property? In order to prevent harm to others, harm to officers, harm to evidence. So if I have a gas leak, and I have risk not only to that particular property and property owner, but to others in that area, then I think I can articulate the exigency, the urgency with which we need to get that resolved. So if there is urgency, like if I don't do this right now, there's imminent harm to others, officers, or evidence, then that's how we justify that.
All right, love it. Another question from an officer. Let me see here. Another officer in Texas, or I'm sorry, Colorado, Roberto. All right, Roberto, our friend Roberto says, is holding the door open to a hotel room with your foot an illegal search? Here's the background. We recently had a domestic occurring in a hotel where neighboring guests could hear a woman being struck and asking for help. All right. So when we arrived on scene, we sat at the door of the suspected room and did not hear any fighting. We did hear a woman crying loudly and asking her boyfriend why he would do that to her. When we contacted the room, the woman stopped crying and tells the boyfriend to go inside the bathroom. The woman takes a moment to open the door to get herself together. And when she does, she immediately steps out. We asked if we can come inside the room. She denies consent. The boyfriend is actively inside the bathroom. We know this. I placed my foot on the door to keep the door from closing, as I am worried that the boyfriend may begin shooting at law enforcement. I looked up the boyfriend in a trusted law enforcement database, and I found that he has robbery charges, motor vehicle charges, narcotics charges, weapons violations. The boyfriend does come out of the room, out of the bathroom, and converses with law enforcement. Is me putting my foot in the door to prevent it from closing an illegal search under the Fourth Amendment? What say ye?
Under those circumstances, I say no. That is
No,
not
illegal.
search.
Well, let me ask you this. Is it a search or seizure to even begin with?
So she has opened the door for officers, and officers are holding the door open with their foot because hotel doors automatically close.
And she says no consent.
Yep. I would suggest that once I have my foot in that door, I have now entered the home, the residence, the domicile. Yes, that is a seizure.
Yeah.
Yep.
Yeah. Some courts will call this a search. I think the better, if your intent is not really the search, but just basically contain it and to kind of control it, it's a seizure. Now you say it's good. Why?
Now we've escalated the harm, the urgency, that exigency. We have addressed the harm to the girlfriend by having her at the door with us. He cannot harm her anymore, but his based on what I know about him and his priors and his violent offenses, and I think we have clear probable cause that an offense occurred based on going back to our reliable source of information with a basis of knowledge who actually heard the domestic in progress. So we've got that reliable source of information with a basis of knowledge that our officer has corroborated with the crying and the why would you do that? Even though I did not hear the fighting at the time, I heard the aftermath of. I think that corroborates that. So I have clear probable cause that a crime occurred, and now I have. I think I have at least probable cause based on my knowledge of this person's past, especially if it's recent past, to believe that motivated to evade arrest.
Right.
And likely to be armed and dangerous at the time. So I think I have enough to justify harm to others, harm to officer.
I agree. Brian says that, maintaining status quo, Brian, that it's part of it, but we also need to be lawfully present. We can't just maintain status quo if we're not also lawfully present. But like Ann said, we are lawfully present here. We are lawfully maintaining status quo because of the clear danger to officers if we allow this guy to, basically barricade himself in that bathroom. I have nothing else to add. I think you did perfectly, described that perfectly as far as the constitutional issues in my view. The final one we
Amanda
have,
added-
go ahead.
Yeah, Amanda added just really quick. Can we articulate entering to arrest, or do we need a warrant? It really does depend on what state you're in and whether or not that's an arrestable offense. But I do believe that if we can articulate that this is a serious offense that we can arrest on without a warrant, that would also give us, again, the exigency, the urgency to make that DV arrest.
I'm going to have
It's
to,
already entered. I mean, we've already justified the.
oh, I
entering.
see. You're okay. That's what, okay. But let's make sure that we're on the same page then, right? Because this is a very good point. Because we've already made the entry, it's irrelevant that we also grab and go.
Yep.
But if, let's say that she does come out of the home or the apartment or the hotel room, and we don't have any exigency. We let the door close. We don't feel any danger. It's whatever. A battery occurred, but we don't have like, what do you think about her saying, no, you're not going in there? He is kind of making it clear you can't go in there. Are we in a state which is a shell arrest? Yes or no?
So yeah, once we're out, now we have to justify going back in. And so I would have to be able to, again, articulate harm to others, harm to evidence. And if he's, I think at that point we're in a much different situation.
We would have to justify the reentry if she's not, first of all, and we make sure too, it's kind of tricky here. If look, we have the PC, we're just saying, but he's also saying, I ain't coming out, leave me alone. This is a bunch of BS. And she's also not, even if she says, go and get him. If he is a guest at that room, which it appears that he probably is, he cancels her out. It's just one of those weird situations. Now you can kind of go down the rabbit hole and says, what if the hotel wants them out now? That would definitely change things, because that they can be evicted immediately for, fighting and so forth. But imagine this was their home. Cops sometimes believe that a shell arrest allows them to enter a home with PC alone.
Nope.
That is not true. That is not true.
Nope.
Your legislature cannot tell you to do something that it violates the Fourth Amendment.
Right.
All right. Would it be like fresh pursuit? Not really.
No, because fresh pursuit or hot pursuit, the arrest starts outside of the home.
Correct.
Yeah.
Correct. Okay, our last one, and we'll see if anybody has a last mic question, but we're almost at an hour here, so it's just kind of what we want to aim for. The last question comes from Kristen in Arizona. Shell gas station reported a suspicious previous shoplifting suspect in the store, fingering items like sunglasses, hats, bandanas, vehicle. So he's basically kind of casing the place. There's a vehicle idling outside with a male behind the wheel. Was described as a red pickup truck. Upon arrival, the deputy observed the license plate was covered with a black flexible plastic, let's say covering. And then the deputy removed the plastic in order to read the license plate and place it in the bed of the pickup truck. Called the plate into dispatch and then ID'd the driver and suspected shoplifter. The sergeant said that the gas station was a private property and that the vehicle owner had the right of privacy shielding the plate. The deputy felt it was an active investigation, exigency, no right to privacy also in the plate, and so forth. All right. This is a little weird one, but I really do like the question. Ann, what do you think?
I think Brian nailed it. We definitely have a Jones issue that touched with the intent to gather information. But the ultimate question comes down to then, do you have a crime in progress? What is your statute about driving around with obstructed plates? And most states have a law that you cannot have an obstructed plate. So yes, you're in a parking lot, but it's private, open to the public. And the question would be, you got there by going on public roads. You will leave.
So do you think we have PC then? I mean, in other words, if we were going to, if we were just driving and we saw this, forget the shoplifting call. There's no call for service. We saw this red pickup truck at the gas pumps. Can you pull behind that vehicle and start scratching a ticket with the obscured plates?
I think it would have to be in order to scratch but yeah, I think you could, because you can't articulate that it just came off of the street to get to the gas station. It's going to be back out on the street. So I think you can at least make the traffic stop, talk to them a little bit about where they're going, why they're going there, blah, blah, blah. And because if you did not actually see the plate covered while they were on the street, I think you'd have to do a little bit more investigation. But I do think it gives you probable cause, at least reasonable suspicion to stop, probable cause to take the cover off. But
Yeah, it's not the cleanest case. I mean, look, and then
Yeah.
Brian says PC for who? That's another question. I mean, let's say it's the lone person by the vehicle pumping gas,
Mhm.
and he says, and the cop says, "Hey, are you driving this vehicle?" And the guy says, did you drive this vehicle, or is this your vehicle?" And the guy says, "Yes." I think push comes to shove. I think I agree, and I think that probable cause is a relatively low standard. It's just, was there a fair probability that he committed a violation? He is at a gas station. Gas stations are temporary places for vehicles. It's in front of the store. It seems reasonable. Oh, and also the Kristen said that the vehicle is running. That's another indicator that's being driven on public roads.
Yep.
It's weak. It's a weak case. So the answer is, and it is a search, right, under Jones, a Supreme Court case from 2012, because that's where you trespass on people's property with the intent to gather information.
Mhm.
This is a trespass. You are trying to gather information, but it could be done, to gather information about what? The shoplifting, the plate violation, or both?
The plate violation is I think is the clear one.
Yeah.
So long as I have probable cause for that search, it doesn't really matter what I learn based on that search. So yeah, obviously I'm going to be able to identify the vehicle, the registered owner from that, but my basis is I have probable cause that you have committed a crime. The crime is covering your plate. I'm going to search to make sure it's actually, the other thing, remember, so it was idling, but there was still someone behind the wheel. So you did have someone in control of that vehicle at the time.
That's right. That's right. So it's even a stronger case. I say we split this one down 50-50, because I think that the officer probably wasn't thinking that he was enforcing any kind of obstructive plate. He was probably just doing it to gather information for his shoplifting, which we probably couldn't do at this point. We have no inventory. The plate is not related to the shoplifting issue. We don't have probable cause for a motor vehicle exception for the shoplifting. But the sergeant is right about that. But objectively, push comes to shove, it probably was fine. So if the vehicle came back stolen, I don't think we lose our evidence, and don't give me I don't like the inevitable discovery business, my friends. We don't do that at Blue to Gold. We like to get stuff clean on the front end so that your prosecutors don't have to argue inevitable discovery, right? Right, Ann? Okay.
Right.
Well, look, I think, let me just make sure here that that's all I had for that's all. Look, that's all I had, for the questions. And we also had some live ones. If somebody wants to ask one last live question, we'll take it. Just say Mike, and we'll ask one last search and seizure question. If not, that is fine too. Brian says, what about detaining to ID for previous theft? Look, we have no problem detaining these people. That's not the issue. The issue was moving that cover a search? The answer is yes. Was it reasonable? The answer was yes, because of the violation. So two different things there, but I would not search that vehicle for ID, for the shoplifting, unless I had a reason to believe that the guy wasn't identifying himself, or false ID, something a little bit more. All right. You're welcome, Kenneth. And my friend, I think this was our first search and seizure show in a very long time. I personally thought it went great. What do you think, Ann?
I think it went awesome. Thank you so much for asking me to come on again and hang out. My great friend and the great and wonderful Anthony Bandiero, the man behind the mask.
Well, the man in front of the guns. That's
right.
All right, guys, we're going to be doing more of these. I am also going to have various, special guests, because I'm, to pick people's brains. And also we're going to hopefully turn this into where we can actually have multiple guests and search and seizure instructors. I think that's really be a lot of fun. Thank you so much, guys. Hey, Rick, do me a favor. We're going to stop this recording, but do me a favor. Can you please put in the Google review URL? Or put in next week's webinar as well. Guys, thank you. For those who are watching online, thank you so much. And again, thank you, Ann, for joining me. I know you're busy, and you just great commentary.
Yeah, absolutely. You guys be safe out there. And thanks again, Anthony, so much. You guys just keep getting it right.
Thank you. Every time.